Litigation Fundamentals with Henry Quillian, also known in-house as Quillian's Kernels. Today we'll be discussing enforcement of document subpoenas in federal court against non-parties. Thank you for coming. As we remind those always that are watching this on video, we are not providing legal advice. We are providing information you can use in connection with your own practice of law or in discussions with your attorney regarding how to go about litigation processes. But it is incumbent upon you to rely upon the advice of your own attorney or your own skills and research as an attorney to come up with conclusions you think are best for your case. As mentioned, there's the circumstance in litigation when you have a case pending in federal district court somewhere, and we'll eventually get to the Northern District of Georgia details, for you to obtain only documents from a non-party. That would be a person or an entity that is not a party to the litigation. And in those circumstances, you want to be able to get the documents and the documents only, but you want to follow the rules that will allow you to get those and not get bogged down in having to redo things or to be in an embarrassing situation where you do something wrong or can't accomplish the task of getting the documents. So we will walk through those procedures. Also, one of the most important things we will cover is what happens when the party you subpoena does not provide the documents you have subpoenaed, and how do you go about getting that non-compliant party to actually comply, and what are your remedies when you try to do that. So we will start with Federal Rule of Civil Procedure 45, which is the rule in the Federal Civil Procedure Act that relates to subpoenas. It relates to subpoenas broadly with respect to discovery, including discovery subpoenas for depositions, etc. But as mentioned, there's the opportunity under Federal Rule of Civil Procedure 45 to seek only documents from a non-party. So this is a relatively narrow litigation fundamentals because it relates to principally only to that, though the rule as a whole is much broader. So if you are a party and you want to get these documents from a non-party, you would need to issue a subpoena, and a subpoena that specifically is associated only with getting documents. You probably have heard of a subpoena ducus tecum, which really means bring them with you, and that generally is used for a deposition where you're trying to get somebody to come to the deposition with documents. But a document subpoena asks only for documents. And of course, there are forms that the federal court has for purposes of a subpoena. That subpoena will need to be filled out, and generally speaking, it will have an appendix or an exhibit which details the documents you need. Well, one thing to think about while you're doing that is that the rule itself in the Rule 1145D has various restrictions on how much burden a litigant can place on a non-party without taking into account the fact that it's perhaps very expensive or problematic for the non-party to actually respond to the subpoena. So consider carefully what you actually need from the non-party and draft your subpoena appropriately narrow so that you will only be getting what you need and not sending the person on a wild goose chase or have a lot of objections that are going to be sustained associated with the expense or the burden of producing the documents. And that's, I think, a commonly problematic thing where somebody just attaches what they used on the last case, asking for everything under the sun, when they only actually need a limited number or a limited type of documents from the non-party. Also remember that the subpoena can and should, if you're seeking electronically stored information, designate the type and format of information you would like from the non-party, because if it's appropriate for the need, the court will actually enforce that and make the party produce the documents in a form that's most usable for the party subpoenaing the documents and also for those other parties that are involved in litigation. And as you know, there's typically an agreement between the parties that's ultimately issued into an order which says the format in which electronic discovery is anticipated to be provided. So, how does a subpoena go about being issued? Well, the rule provides that you can either get the clerk to issue the subpoena in blank, and then the party that's seeking to serve the subpoena can fill it out, or, as more commonly done, an attorney who is admitted in the court where the subpoena will issue from can sign the subpoena him or herself. And that it would be the more prevalent case these days. And as we get down the course of this discussion, you'll see how that may make some difference, though probably not a large difference, in the way the subpoena is enforced. So we've gotten to a point where we look at the subpoena, we've gotten it filled out, we've got the person we want to get the documents from or the entity. We need to make sure that that person or entity is only being called upon to deliver documents within a certain territorial range from where the person or entity either resides or regularly transacts business, because the court will not want to make a party do that and basically carry the documents more than 100 miles. So if you designate a place that's more than 100 miles away from where the party or entity is that from whom you want to get the documents, that would be a automatic grounds or likely automatic grounds for the quashing of the subpoena. So you need to use whatever mechanisms you can to figure out the distance from where you're subpoenaing the documents you want them delivered. So keep that in mind. Basically, what you want to do is you want to do all your blocking and tackling when you're drafting the subpoena in advance, so that you won't draw valid objections or a valid motion to quash once the subpoena is served. So that at the end of the day, you can enforce the subpoena if there's non-compliance. Now, before you let the subpoena go out the door, you must comply with Federal Rule of Civil Procedure 45A4. That's little a 4. And what that says, and as we know in Quillian's kernels, we always read the rules, and the rule is Rule 45. It says, notice to other parties before service. If the subpoena commands the production of documents, electronically stored information, or tangible things, or the inspection of premises before trial, then before it is served on the person to whom it is directed, a notice and copy of the subpoena must be served on each party. And when they say party in there, they mean a party to the lawsuit. So that is something that must be perfected, and I would suggest it must be perfected at least the day before the service of the subpoena. And that is an often forgotten, at least as in my observation, a forgotten procedure, which can undermine the enforceability of the subpoena or can subject the attorney who's serving the subpoena to some sort of sanction. The purpose of that obviously is if you're going to get documents from somebody that another party may think should not be giving up those documents, and the other party needs to have a right to object and to control the non-production of those documents, because perhaps it's an accountant for the party or some other party that might go ahead and turn over the documents even though they shouldn't because of some privilege. And if the party doesn't know about it, then they can't act in time to take protective steps. So under Rule 45A4, make sure you serve notice on the other parties of the intent to serve the subpoena. Last time I did that, we filed it with the court, and of course attached the subpoena. That makes sure that everybody that's a party to the action knows it, and you have proof that it was done. And of course, it needs to be served on the other parties in compliance with the rules for service in the federal court. So then, of course, you need to actually serve the party with the subpoena from whom you're trying to get the documents. And that is a task which could be simple or it could be hard. The best, if you got the money, the best mechanism is to use a process server who can actually sign the affidavit indicating the service of the subpoena, because that way you can file the proof of service on the record. You won't have the delays associated with a marshal or somebody else serving the subpoena. And you can get feedback from that person regarding the party you're trying to get the documents from. And more certainty, perhaps, that you've actually given the subpoena to the person that you want to, whose hands you want to get it into. As you know, there's the possibility of process servers or others just leaving something with the front desk or not serving the actual officer of the corporation or whatever the case may be, and you have that uncertainty and you won't find that out until down the road unless you use somebody who's reliable and who can fairly establish that you have in fact given the subpoena to the person you would like to give it to. With that, why don't I take a break and see if anybody has any comments, questions, anything they would like to do to enhance the conversation. And I believe you can simply get yourself off mute and make a comment. Okay, not hearing any. We now have served the subpoena, and then of course the proof of service needs to be filed with the court so that you can establish the fact the subpoena has been served. I suppose at that point in time, it's a waiting game. We would suggest that because, and I'll go into this in a minute, there's an opportunity for the non-party to object to the subpoena, that the subpoena production date should be, if at all possible, at least, well, 14 days or more past the date it's served, so that when the when the party gets the subpoena, they will have the time allowed by the rule to object. Now that objection can be on numerous grounds. Obviously, it could be on privilege grounds, and it could be on burden grounds, or it could be on other grounds, such as seeking to protect proprietary information. That's under Rule 45D2B, and it suggests a variety of reasons by which a person who has been asked to produce documents might object. Of course, if they had under that rule, there's only 14 days to object to the subpoena. And as you may not be surprised, if the party does not object, they can end up waiving objections that otherwise might be assertable, to be determined down the road by a court. So we get to the point of what happened if the party produces all the documents, then you're golden. You need to have them sent. The subpoena itself needs to direct them to be delivered at a particular place and time, because if you just say send the documents to my law firm, you may not even know when they get there or to whom they were delivered. But if it says to the second floor of the law firm, and you are there waiting for them to be delivered at the appointed place and time, and they don't show up, then you'll have a pretty good evidence they never got there. And of course, you might get a call from somebody in between the service of the subpoena and the actual production date, in which you might make some adjustments to the subpoena. But if you do that, you better be very clear with respect to what you expect, and that it's not a waiver of the actual subpoena itself until and such time as compliance has been achieved. So now we're up to the point of what happens if the documents don't come. You serve the party, could be a company, could be an individual. You've designated the time and place of production. The time and place of production is reasonable. Your subpoena is properly tailored to the needs of the case, and the documents just don't appear. What do we do now? Do we file? How do we analyze what can be done in this circumstance? Well, that comes down to an issue of what is a subpoena and what are the remedies for a subpoena. What a subpoena is not is a request for production of documents under Rule 34. It's under Rule 35, and Rule 34 relates to request for production between and among parties. So the subpoena itself is actually considered to be an order of the court. If you look at it, it will actually be a mandate from the court. Now, in that it is signed by an attorney that who's an advocate for one of the parties, as will be discussed in a minute, some courts have thought that it doesn't have quite the weight, I guess, of the judge, him or herself, actually issuing the demand for production. So we have a situation where there's nobody has responded to the subpoena, and you haven't received any objections, and that brings into question Rule 45G, and that part of the rule is entitled contempt. And it so happens that we have authority from the Northern District of Georgia that describes what contempt is and how it is associated to a subpoena. This case that I have in my hand is Smith versus Pefanis, P-E-F-A-N-I-S, 652 Fed 2nd 1308 2009. It's written by Judge Forrester, but it's an action taken after a report and recommendation of Magistrate Judge Vineyard, and it goes into some detail as to what contempt means and how you go about establishing it. So there's two types of contempt. One is civil contempt, and the other one is criminal contempt. And it says civil contempt is a process used by the court to compel compliance with a subpoena or court order. Criminal contempt is penal in nature and requires compliance with the protections that the Constitution requires in criminal proceedings. A contempt fine is considered civil and remedial if it either coerces the contemptor into compliance with the court's order or compensates the complainant for losses sustained. And then in a separate part, it says the role of criminal contempt is to protect the institutions of our government and to enforce their mandates. A federal court may impose criminal contempt sanctions pursuant to 18 U.S.C. 401 to vindicate its authority and safeguard its own processes. I don't believe we're going to be covering criminal contempt in this scenario, because let's hope that with proper procedures, criminal actions can be avoided by the court exercising its civil contempt powers. So the question comes, how do you get to the point where you actually wrangle these documents out of the party to whom a subpoena has been served? And I am going to ask Anna Edmondson to describe how that is done in the Northern District and how it might be different in other districts. Anna, if you're there, please chime in. Molly, do we have the mics open?
Hey, can you hear me?
We can hear you.
So in the Northern District of Georgia, they won't issue contempt sanctions until a party has not complied with both a subpoena and a court order to comply with the subpoena. So you have to first get the court to order them to comply, and then afterwards you have to wait till they don't comply with that, and then you can reach out to the court for sanctions.
And why would that be different from just, since a subpoena is a court order, why wouldn't they just hold somebody in contempt right away for not complying?
Well, I think the advisory committee commented to Rule 45 and said that because a subpoena may be issued by counsel with no court approval, the command of an attorney issued subpoena is effectively that of the attorney and not of a judicial officer. So whether it's out of heeding that advice or the interest of courtroom efficiency, the Northern District of Georgia follows that guidance.
Okay, and what would need to be filed in order to start the process of getting compliance with the help of the court if a subpoena that's issued, signed by an attorney, goes out and nothing comes back? In the Northern District of Georgia. Got that, Anna?
Sorry, can you hear me?
Can now.
So basically, you'll want to request contempt sanctions, but only after the court's ordered the compliance. So you're going to want to reach out to the judge that's assigned to the case, but you're also going to want to look at their standing orders to see what they first require. They all require different things. So for example, Judge May requires that parties request a conference with the court before formal motions to compel are filed. Other judges require that parties file the consolidated joint discovery statement to the court first, and then they'll require a conference.
Okay, so standing orders sometimes come into play, and the court may not want to see anything official filed with the court until those either a request for a conference, which I guess in Judge May's instance is a one-page description of what the problem is by the party who has issued the subpoena. And then others, like I think he said under Judge Batten's, he requires the parties to the litigation to submit a joint paper saying why the documents are needed or what has happened.
Correct. That's also for Judge Booley and Judge Totenberg. Then the court will determine if it can be resolved on the papers or whether a conference is necessary.
Okay. Well, you know, one thing I failed to mention is, what if no documents come, and this isn't really a question to Anna, but what if no documents come and you've actually heard from the party that received the subpoena and have had communications with them? One thing we need to remember is there's a need for a good faith conference if it can be had before going to the court at all. We had a case recently where insurance defense counsel had been appointed for the party that we subpoenaed after the subpoena was served, but that insurance defense counsel was appointed for the same underlying subject matter, but for a different lawsuit filed by a different party in state court. So we undertook to have good faith conferences with those insurance defense lawyers, even though they had not entered an appearance in the federal court action. And initially, they basically didn't do anything. It appears that their insurance companies didn't hire them to respond to subpoenas in federal court, so they simply didn't do anything. They may have talked to the client and said, hey, you ought to comply with that subpoena. But if they did, we don't really have any knowledge that that was accomplished. So But we did put that in our one-page description to Judge May of what we had tried to do in order to get compliance. So if the court were to hold a conference and get compliance, then obviously that would avoid the need for any sort of additional official action. But if there is, if the court cannot get compliance, Anna, what sort of first round motion would you file with the court?
You'd file a motion to compel.
Okay, and would that be under Rule 37?
45.
Okay, so it's under Rule 45. And because it's under Rule 45, it's just basically saying, and there's a need, by the way, to establish your evidence of the service of the existence of the subpoena, the service of the subpoena, a good faith effort to resolve it, and that there's been no compliance. So that will require submittal of evidence, an affidavit, reference to the proof of service, affidavit confirming the subpoena, a certificate establishing good faith, which obviously might have already taken place in the conference with the judge. And then the hope is to get an order compelling production of the documents from the party that didn't respond, in which case you would have a court order telling this non-party, not only did you get a subpoena, you didn't object, you have to produce these documents and you have to produce them within X number of days. And then what has to be done with that order? The non-complying party actually has to be served with the order. Otherwise, you won't be able to establish contempt down the road. So unfortunately, that means you have to tag the party a second time. Sometimes you catch them cold when you serve the subpoena, find them where you think they should be, get the subpoena served, and you're able to accomplish that. But then if you get the contempt order, you need to be able to have proof that you served it upon them. And of course, the best type of proof would be an affidavit saying I put it in the person's hands from some sort of process server. But otherwise, I guess you'd try to send it to them every which way you had to communicate with them. And then if there's no compliance, then you would need to go back to the court again. And in this instance, there would be a necessity of proving by clear and convincing evidence, as mentioned in the Panifus case that I quoted earlier, that you had taken these steps, that there had been a valid court order, that the order was clear and unambiguous, and that the violator had been served and they had not complied with the court order. In which case, it would, if you were able to get all that established, then you need to, the court would most likely issue an order to show cause why the responding party should not be held in contempt. And that would be an actual evidentiary hearing called before the court at a specific date and time. The burden of production shifts over to the responding party to prove why they shouldn't be held in contempt, as opposed to on the moving party to show why there is contempt. Because once you filed your motion for contempt and convince the judge to issue an order showing cause, the other party better show up with some evidence as to why they couldn't comply. Why what sort of excuse is there? And there's a case which is Pravin, P-R-V-I-N, Patel, and lots of Patels versus B-H-A-K-T-A, Bhakta, which is a 2015 case out of Northern District of Georgia. It's Judge Clay Schofield as a magistrate judge, 115 CV 562. And he goes into fairly detailed analysis of how an attorney and a bunch of clients failed to respond to subpoenas and how they can be found in contempt. And then the question arises, so what sort of remedies can the party seeking the documents get, other than just the documents themselves and contempt? Well, unfortunately for the party that needs the documents, the only remedy is getting the documents. The courts have held that Rule 45 does not have an attorney's fees provision within it. And so, though it could be within the power of the court to issue an award of attorney's fees to the party seeking the production of the documents, there's no express right for recovery of attorney's fees like there is under Rule 37 for a failure to produce documents under Rule 34. And that is also covered in the Patel case. So just don't overpromise to your client the remedies you're going to be able to achieve if the party that you're seeking documents from does not produce the documents. But it should be a powerful tool if you draft the subpoena appropriately and have it dedicated to the facts that need to be presented in the case, and don't go overboard asking for expensive productions that are unnecessary to achieve an outcome that gets you the documents. Does anybody else want to chime in with any questions or comments or experiences? Okay, well, thank you to Anna Edmondson of Taylor English for her participation and guidance today. And we thank you for attending Litigation Fundamentals with Henry Quillian. Take care.